Good evening, everyone. We had several filings drop today, and I know we don't all have time to sit and read all of these. So if you just want to listen to them being read, I'm just going to read the document, no commentary. This one is going to be Wayfarer's response to Lively's opposition to the motion for summary judgment. So we're just going to get right into it. And it starts off with a table of contents, which I'm not going to read, so I'm just going to scroll through that. You can come back and look at this if you want. And here we go. Lively spills lots of ink attempting to conjure up factual disputes, but the material facts are undisputed. Her opposition and 56.1 response confirm she has launched a massive campaign to address minor grievances, all of which were resolved during production of the film without the need for any litigation at all. She recites a litany of subpoenaed harassments, ranging from yelling to defensiveness to a conversation Lively herself initiated about Redacted to an incident she assured at the time was a non-event but cannot say any continued after she asked for them to stop. They did stop. And then the parties worked together to produce a successful film, bringing her not only riches but an extraordinary set of professional accomplishments she touted to the Producers Guild of America as a rare achievement for a woman. Not satisfied, she now claims discrimination, arguing, among other things, that her bespoke, heavily negotiated contract was violated, even though she never signed it, and that despite her total near control over the production, she was merely an employee. She also claims defendants unfairly resorted to professional PR firms for guidance, even when she and her husband openly badmouthed Baldoni and ginned up a flurry of negative press against him. She alleges a massive smear campaign, but fails to point to a single falsehood any defendant uttered against her. Lively's claims do not meet the requisite standards. Motion summary judgment should be granted. Argument 1. Lively cannot prove any actionable sexual harassment. Nothing in Lively's opposition overcomes the clear reality that she alleges low-level behavior, trivial grievances, and petty slights. Redacted yelling, and the other assorted conduct she alleges may be bothersome, but they do not rise to the level of discriminatory, hostile work environment. Lively apparently recognizes Baldoni's conduct doesn't get her there. It boils down to a comment about Redacted after she raised the topic and before she agreed to work on the movie. Discussions about sex and sexiness while collaborating about how to depict an intimate relationship and sex scenes, and a remark about her weight made offset to a person uninvolved in the film, Saldoni declaration. She thus now attempts to make Keith the poster boy of sexual harassment. Based on what? A brief glance, an already awkward situation after which Lively undisputedly told Heath, "I'm not saying you're trying to cop a look." Heath showing her a video related to his child's birth, shared in the context of producing a film with a prominent childbirth scene. When it is disputed, Heath showed the same similar image to Baldoni and to Redacted, who found it hopefully inoffensive. It is remarkable that after months of discovery, Lively cannot muster anything more to justify the tremendous legal and judicial resources devoted to this case. It is even more remarkable because whatever concerns she may have had were fully resolved when she raised them. Even Lively does not meaningfully dispute that the entire second phase of filming, including all intimate scenes involving Lively, occurred without incident. Lively cannot establish the conduct at issue was aimed at her or anyone else because of gender, a basic prerequisite for a sexual discrimination claim. She concedes that alleged conduct affected women and some men. She abandons her various allegations, such as improper hugging, because she cannot dispute that both men and women were hugged. Lively's own evidence further undermines her claims. It confirms Baldoni's stated motivation was privately inquiring about her weight was not to demean her as a woman, but to anticipate his own physical obligations. Redacted. Saladino declaration is what is cited there. There's more redacted. Lively's trainer's opinion, redacted. Saladino declaration is neither admissible nor competent evidence on summary judgment, nor does Lively dispute that she herself repeatedly raised concerns about Redacted. Lively continues to complain that Baldoni once complimented her personal outfit and, later that same day, referred to her wardrobe as sexy. Lively strains to suggest her costume was revealing, but cannot dispute video footage showing it was, in fact, an oversized fleece onesie. Nor can she show that that this was a gendered attack. Lively notes Baldoni similarly referred to a male actor as redacted, while Lively herself joked about redacted, another male actor to market the film. Blink proclaimed that redacted, and insisted upon the redacted of her character's wardrobe on more than one occasion. Sexiness was indisputably used at times to describe a film devoted to adult themes, not invoked to pit one gender against another. Lively also complains that Baldoni improvised physical intimacy. Lively adduces that no evidence to suggest he did this to offend her based on her gender. Baldoni was not targeting Lively as a woman. He was in character filming a scene in which, as Lively puts it, his character and Lively's were redacted. Such conduct would not be acceptable in a typical office setting, but in the context of two professional actors making a romantic, sexually charged movie, it cannot constitute discrimination. Lively's own declaration describes other kissing scenes in the film as vital to conveying the redacted. Her complaint that Baldoni added intimate scenes fails for the same reasons. Lively does not dispute that she, too, revised the script to increase the redacted. Any gendered animus is further undermined by undisputed facts that Lively was invited to discuss her views about the intimate scenes with the Fail Intimacy coordinator before filming and propose revisions. Lively's efforts to evade this conclusion by characterizing the film's birth scene as unscripted nudity is absurd, and she claims she was unexpectedly required to imply nudity, redacted, under a hospital gown and prosthetic belly. But Lively, a mother of four, must have known people generally do not wear pants to give birth. Nor were comments Baldoni supposedly made to Lively about his personal experiences gendered. It is undisputed any such comments were substantially similar to statements Baldoni has made in talks and books aimed primarily at male audiences. Lively also notably does not dispute that she shared her own views about intimacy with Baldoni during Redacted about the film. 2. Nor do the two alleged incidents involving Heath provide any evidence of gender discriminatory animus. Lively cannot dispute that 3 witnesses testified Baldoni asked Heath to show Lively the birth video for non-gender based reasons, following discussions about the birth scene in the film. Indeed, she admits Baldoni contemporaneously told her redacted. After Lively objected, no one persisted in showing her the video. It is undisputed that Heath also showed the video to Baldoni, a male participant in the film. Similarly, Lively admits Heath entered her trailer once not for any gender-related purposes to discuss Redacted, with her permission. Lively asked Heath to turn away from her, and he indisputably did. She claims that at some point he glanced her way, but doesn't dispute later assuring him, "I'm not saying you're trying to cop a look." She cites no evidence supporting her claim that she raised the incident with Heath redacted, nor is there any evidence she raised it during the call with Sony executive a few days later when she redacted about the production. And while harassing conduct seems, sorry, and while harassing conduct need not be motivated by sexual desire, Lively omits that the very sentence she cites for that proposition underscores that the conduct must be motivated by gender. She cannot make that showing here. Lively defends her reliance on limited, sporadic, one-off incidents of alleged misconduct by citing one case in which a single incident sufficed, Bailey versus San Francisco's District Attorney's Office. In reaching that conclusion, the court was clear that isolated incidents must be extremely serious to give rise to an actionable claim. Unlike here, the incidents in Bailey involved an unambiguous racial epithet, the N-word, a slur so universally recognized that its discriminatory intent cannot be denied. 3. Beyond Heath's conduct, Lively does not even claim anything she personally experienced was sufficiently severe or pervasive to prove harassment. She largely ignores significant authority confirming her allegations are too mild. She dodges the undisputed critical fact that any alleged harassment ceased once she raised concerns, no issue arose, and no incident recurred throughout the remaining filming. And that was not just defendant's view, it is undisputed that redacted. Sachs testifying the set was redacted. How could the conduct be severe or pervasive if it is vanished once the issue was raised? So much so that Lively, advised by counsel, concluded no formal HR process was warranted. Even the authorities' Lively claims supported a relaxed standard, sorry. Even the authorities' Lively claims support a relaxed standard require proof of severe or pervasive conduct for a hostile work environment. For example, Bailey confirms that simple teasing or offhand comments and isolated incidents, unless extremely serious, are not sufficient to create an actionable claim of harassment. Lively relies repeatedly on Cal Gov Code 12923, a 2019 proclamation from the California State Legislature declaring its intent that summary judgment is rarely appropriate in harassment cases. The proclamation has no bearing on Lively's Title VII claims and by its terms merely states a legislative view. California courts have also confirmed that it does not mark a substantive change in California law. Indeed, federal courts in California continue to grant summary judgment in FEHA cases where severity is not shown. Lively tries to bolster her claim by invoking the alleged experience of other women. There is no evidence that Lively knew about most of these alleged incidents prior to litigation, if they even occurred. Several of these alleged incidents are supported only by rank hearsay or otherwise inadmissible evidence. Such unsupported claims must not be considered. Moreover, the conduct she discusses adds little weight to her claims. Like Lively, co-star Jenny Slate refers to a single instance in which Baldoni referred to her wardrobe, which included black leather pants, as sexy, a term which, as noted, was widely used on set, including by Lively herself. A one-off remark may be unwelcome, but it is not so severe or pervasive as to rise to a claim. It is undisputed that Baldoni acknowledges Slate's concerns, redacted. Lively also claims Baldoni yelled at a female producer, Alex Sachs. Yelling without more is not evidence of gender bias. Even Sachs resists such an interpretation, noting that Baldoni treated men similarly. Defendants have a way of making women and some men feel like shit. That was the quote. Lively references to verbal abuse supposedly experienced by another director on another set of a different film have nothing to do with the work environment at issue in this case. In any event, the alleged verbal abuse is only vaguely described, with no suggestion it was either sexual or gender-based. Likewise, the claim that author Colleen Hoover was not involved in the script and did not receive dailies has no evident connection to Hoover's gender or to the set environment. Finally, Lively criticizes Baldoni, redacted. There is no evidence it was gender-based. 5. Because, as is now disputed, all the issues Lively raised were resolved, she cannot show that the conditions of her employment changed. This is yet another reason to dismiss her claims. Lively argues that even though she voiced no objections during the second phase of filming or thereafter, defendants' huffy and defensive reactions to Lively's behavior were themselves harassment. But the two occasions in which Lively's claims that occurred were both during the first phase of filming. Regardless, the law is clear that such minimally unfriendly conduct does not amount to the change in the terms and conditions of employment required to prove a hostile work environment. On the contrary, the Supreme Court has repeatedly stated that the standards for judging hostility are sufficiently demanding to ensure that Title VII does not become a general civility code. 2. Lively cannot prove any actionable retaliation. Perhaps aware of the shortcomings of her argument, Lively insists very little evidence is required. What she is not what she has is not enough to save her retaliation or aiding and abetting claims. Lively's claim that she has made a prima facie case fails on multiple grounds, and even if she has, defendants have presented a clear, non pretextual justification for their publicity efforts, which were a reaction to a media firestorm and not to any complaint by Lively months before. A. Lively did not experience any adverse employment action. It is now beyond dispute that there is no material aspect of Lively's employment change for the worse. Her compensation did not decrease, her role did not diminish. That alone is enough to defeat her FIHA claims. Lively tried to evade the point by expanding her supposed employment to include post-filming activity as well as her campaign to get a PGA mark. But Lively was not hired as an editor, director, or producer. That she had any role in post-filming activity is proof that her responsibilities expanded, not contracted. In any event, it is undisputed that Lively did get the opportunities and references she sought, including defendants' endorsement of her PGA mark. She described her accomplishments redacted and not as any setback. Lively's complaints that was made to feel guilty and was criticized to Hoover and others are minor or relatively trivial adverse actions that, from an objective perspective, are not reasonably likely to do more than anger or upset an employee, are not actionable. More than subjectively upset the employee or are not to her likings are not adverse employment actions. Any such conduct has no material effect. The record is replete with evidence that after the May 6, 2024 dinner, about which Lively complains Hoover worked closely with Lively redacted. In lieu of any material harm, Lively relies on the CRA to argue that mere changes in attitude or sarcasm could be enough. I'm really sorry. The CRA to argue that mere changes in attitude or sarcasm could be enough. Yet, precisely because there are no material harm, no damages can arise from any alleged contractual breach, even assuming the CRA was a binding agreement, which it is not. B. Defendants' publicity efforts were reasonable defense measures that are not actionable as retaliation. Lively cannot meaningfully dispute that defendants' publicity efforts took place outside the workplace, in the arena of public opinion. Undisputed facts show Lively chose that arena and exercised immense power within it. It was Lively who unfollowed Baldoni, tantalizing media sleuths. It was Lively who disparaged Baldoni to her famous friends. Documentary evidence shows Lively's husband redacted, while Lively redacted, causing a media furor just days after the premiere redacted. Lively's opposition fails to identify a single factually false statement defendant shared or promoted in response to this onslaught. She claims multiple incidences placed Lively in false light, but fails to say which ones or how. She complains defendants exposed her to criticism for past conduct, but does not dispute these criticisms were already in the public domain before any publicity by defendants. Lively faults defendants for supposedly contending she weaponized feminism and took the movie over. But it is undisputed that Lively claimed to have redacted. She also claimed that redacted, clearly invoking a feminist theme. Lively asserts she was unfairly criticized for shifting the film's marketing strategy away from domestic violence. Yet it is undisputed that the film was always intended to raise awareness about domestic violence, and that Lively redacted. In claiming Heath admitted her marketing was redacted, Lively misrepresents. In the very document she cites, Heath expressed concern to Sony about how many people are pointing out that DV is being glossed over and encouraged everyone to be more deliberate in embracing the DV aspect. Regardless, it is undisputed that Lively was criticized not simply for de-emphasizing domestic violence, but for simultaneously promoting her other projects and those of her husband as well. The record is clear that such criticisms appeared in the press independent of any effort by defendants. C. Lively cannot prove causation. 1. Lively engaged in no protected activities after her protections demands. Lively tries to shrink the temporal gap by stretching out her claimed protected activities. That doesn't work because Lively has never before claimed any of the additional events she now relies upon, such as redacted or refusing to remote the film with Baldoni as activity intended to oppose discrimination, and there is no evidence any defendant understood them as such. Elsewhere, Lively describes redacted as immaterial, and her cited evidence does not refer to redacted she now relies upon at all. An action cannot constitute protected activity where there is no evidence the employer knew that the employee opposition was based upon a reasonable belief that the employer was engaging in a discrimination. And even assuming such conduct could constitute protected activity, it is undisputed defendants respected Lively's request. Baldoni did not insist on promoting the film with her. Redacted, a provision Lively never invoked. 2. Lively lacks direct evidence of retaliatory animus. Lively next asserts the temporal gap between her objections and the publicity campaign doesn't matter because she can show a direct causal link. But conspicuously lacking from the record is a single piece of evidence in which defendants say they are initiating a publicity campaign to get back at her for raising objections on set. Instead, she relies on messages in which defendants express concerns about her possible prospective activity and seek to prepare for the fallout. Those cannot prove a retaliatory motive, and it is undisputed that defendants' conduct consistently resulted in Lively gaining more power over the production, not less. 3. Undisputed evidence proves defendants' non-retaliatory motives. Lively argues no admissible evidence shows defendants had a legitimate, non-discriminatory motivation. She is wrong. Undisputed facts show that when defendants decided to engage a crisis PR team, they did so to protect their own reputations and that of the film against an anticipated onslaught of negative publicity, not to retaliate against her. Indeed, Lively admits defendants first met with Tag only on July 25th after negative publicity had already began. Lively lacks evidence to show, as she must, that her purportedly protected activity was the but-for cause of the defendant's conduct. She cannot possibly meet the burden on this record, nor can Lively credibly argue that defendants welcomed a media fracas as a pretext to attack her for her objections. Rather, undisputed evidence, including materials Lively cites, shows that defendants were terrified and doing everything they could to avoid a confrontation. D. Post-litigation conduct cannot save Lively's claims. Lively leans heavily on actions defendants and their counsel supposedly took after she filed her CRD complaint. But if Lively did not suffer any actionable retaliation before commencing litigation, she should not be able to create a claim based on post-litigation conduct. Any such conduct by defendants would be a response to the litigation she commenced, not a response to any workplace complaint about harassment from many months before. 3. Lively was an independent contractor, not an employee. Lively attempts to paint herself as merely an employee. In doing so, she ignores her own extensive admissions, including redacted. She also ignores the highly bespoke contracts she negotiated, including an agreement that the production's location be moved closer to her own home, writes over many aspects of production, and a rider, which was the CRA, insisting on her own unilaterally imposed terms as a condition for going forward. If, as she argues, control is the determination factor in determining whether a traditional employer-employee relationship exists, it is difficult to imagine anyone having more control. The circumstances bear no resemblance to those in Makarova versus United States, the only authority upon which Lively relies. There, the Second Circuit emphasized that the Kennedy Center consistently maintained full artistic control over not only a ballerina's performance, but the entire show. Lively, by contrast, exercised tremendous control over the entire production, as evidenced redacted, and not simply over her own performance. While the ballerina signed a contract writer that bound her to standard terms, Lively dictated and demanded the unique terms of the CRA. While it remained unclear whether the ballerina was paid as an independent contractor, it is undisputed that Lively received no standard employee benefits, nor was she paid or subject to taxes in the manner of a standard employee. Lively's opposition to the ALA Lively's opposition points to the ALA, but the terms of that agreement were never fully negotiated and the agreement was never signed. In any event, Lively is relying solely on the language of a pro forma workers' compensation provision while ignoring the broader circumstances, a particularly myopic approach in an area where courts require a comprehensive multi factor analysis. The application of California's business to business exception similarly cannot be denied where, as here, the work was performed pursuant to a business to business transaction between It Ends With Us movie on the one hand and Lively's loan out and entity Blakely Inc. on the other. The relevant factors set out in California Labor Code 2776A overlap with those of the Reed test or are self-evident from the record, and they uniformly confirm this is a how do you say that? Bona fide business-to-business transaction. Blakely was free from control of defendants both under the contract and, in fact, Blakely was providing services directly to defendants, not to defendants' customers. The punitive contracts between the parties was in writing and specifies the payment amount. Blakely had a business tax registration as defendants withheld applicable New Jersey business taxes. Blakely's business location was separate from defendants. Blakely's customary role was to lend out Lively's acting services, the same services involved in the work performed. Blakely provided the same services to others, advertised itself as available to do so, and even insisted upon an alteration of defendants' production schedule to accommodate Blakely's ability to provide Lively services on another film. Blakely provided the relevant instrumentality for the work. Lively herself, Blakely could and did negotiate its own rates. Blakely could and did demand changes to the location and hours of work, and Blakely was obviously not a member of the construction industry for which a special contractor's license is needed. Because this was a business-to-business relationship, the Borello test, which is materially indistinguishable from the Reed test, determines Lively's independent contractor status under California law and thus yields the same outcome. Like Reed, Borello examines circumstances holistically, considering, among other things, the right to control and secondary indica like the skill required, which provides the instrumentalities, the duration of the work, and the method of payment. Far from a typical employee, Lively independently contracted through her own private business entity and exercised tremendous control while maintaining the right to work on other projects and for other businesses. If she is not an independent contractor, then there is no such thing as an independent contractor.
4. Lively cannot prove a failure to prevent investigate claim. Lively knew how to raise concerns, and she did. Heath and Baldoni may have disputed her version of events, but they never acceded to her demands. And although Lively's brief asserts defendants failed to implement any corrective measures, her 56.1 response admits It Ends With Us movie agreed to a set of requested protections through which a redacted set was achieved during all subsequent filming, including all intimate scenes featuring Lively herself. Lively also cannot dispute that through her legal counsel, she declined to pursue formal HR process. Lively tries to rewrite history, claiming an investigation didn't happen because Heath didn't want redacted. That claim misleads the court by twisting Alex Sachs' deposition testimony, 56.1 opposition, and is not supported by competent evidence. Sachs actually testified that when she first suggested an investigation, redacted. Sachs further testified that she surmised Heath's desire not to have redacted based on her own interpretation, not anything else Heath ever said. Sachs' private speculation about Heath's motives is not admissible evidence. Also, fatal to Lively's claim is the lack of evidence suggesting any failure to prevent or investigate harassment was a substantial factor in causing her purported harm. It is undisputed that Wayfarer had appropriate policies and Baldoni and Heath participated in workplace harassment training because any allegedly harassing conduct ceased once Lively voiced concerns. Any subsequent failure to investigate cannot have contributed to any harm either. Contrary to Lively's argument, there is no causal relationship between the adequacy of defendants' on-set policies or their decision not to conduct a formal investigation and the gravamen of Lively's complaint, a so-called retaliation complaint consisting of social media activity months later. 5. Lively's contract claims fail. A. Lively has abandoned her breach claims against Wayfarer. Lively makes no effort to defend her alter ego theory breach of contract claims against Wayfarer, which, unlike It Ends With Us movie, was not part of the ALA and CRA. The claims against Wayfarer must therefore be dismissed. B. The ALA is not binding or enforceable against the entity defendants. Lively does not dispute redacted. Lively's arguments to salvage her breach of claims in the face of those undisputed facts all fail. 1. Judicial estoppel does not apply. Contrary to Lively's argument, the entity defendants are not judicially estopped from arguing the ALA is not binding. Judicial estoppel applies only when a clearly inconsistent factual position has been adopted in some way by the court in the earlier proceeding, such that a party would derive an unfair advantage by changing tack. First, the court has never previously adopted any position advanced by defendants with respect to the ALA. In an order of dismissal, it rejected defendants' only arguably related claim. Second, defendants' prior pleading was not inconsistent with their current position. Its two pointed out that the ALA had never been signed. It asserted a claim for breach of the covenant of good faith and fair dealing that was never specifically alleged to rest on the ALA. As noted in defendants' opening brief and below, the parties performed pursuant to a separate offer letter. Third, the entity defendants gained no unfair advantage based on the alleged inconsistency. In dismissing the prior claim, this court noted allegations that the ALA had never been signed, and defendants chose not to replead the claim, though leave was granted. 2. The condition precedent was not waived and no agreement was formed. Lively falsely claims defendants confirmed in writing that Wayfarer was waiving execution. That did not happen. The cited evidence shows Heath told Lively's reps, we have withdrawn a request for your client to sign her agreement in order to extend the time with the edit. Heath gave Lively more time to edit the film without signing the draft ALA a condition of the concession. Heath was clear the contract negotiations remained open. He wrote, as for the future resolution of the contract, we will stand by in hopes that we come to a conclusion soon. Lively also falsely claimed It Ends With Us movie did not dispute the execution condition had been waived. The opposite is true. When Lively tried to strike the execution condition and claim it had been redacted, It Ends With Us movie rejected that edit. Lively doesn't dispute that fact, though she labels it misleading, claiming It Ends With Us movie could have more explicitly rejected her assertion of waiver. But It Ends With Us movie was unequivocal that it was not waiving that condition. When Lively later tried to insert the phrase redacted into the draft, It Ends With Us movie again rejected the edit. B. Nor did It Ends With Us movie waive via its conduct. Indeed, Lively's own evidence confirms that because the ALA was not finalized when principal photography commenced, her lawyer insisted that until such time that the long form is fully executed, our client will continue to proceed in reliance upon the terms of the negotiated deal memo. In other words, the parties would rely upon the offer letter. Moreover, both New York and California law require unequivocal expression of intent to waive, especially where, as here, the contract expressly bars modifications not signed and in writing. Lively can't show unequivocal intent to waive here, given her pre-dispute assertion that pending execution of the ALA, the parties would perform under the offer letter, her repeated unsuccessful attempts to remove the condition from the ALA, and It Ends With Us movie conditional request that she sign the agreement. C, for similar reasons, the ALA was never binding, as noted above. Lively does not meaningfully grapple with undisputed evidence showing the parties did not intend to be bound, absent a full executed writing. Instead, Lively merely claims that by July 2nd, 2024, most of the draft ALA's terms were final, and the remainder, she says, were immaterial in practice. It is irrelevant, however, whether many key terms of the ALA were apparently no longer subject to negotiation, because it is black letter law that if either party communicates an intent not to be bound until he achieves a fully executed document, no amount of negotiation or oral agreement to specific terms will result in the formation of a binding contract. Lively's arguments that the ALA were performed also fails because Lively cannot meaningfully dispute that performance occurred under the offer letter, which set forth the key terms between the parties. In any case, performance is only one factor for determining whether an agreement is formed and is not decisive. Lively's argument that execution of the CRA suggests the parties understood that ALA was already a binding agreement is flatly contradicted by the record. It is undisputed that negotiations over numerous provisions of the ALA, including the provision making execution a condition precedent, continued after the CRA was signed, with neither side manifesting an understanding that the terms of the ALA were finalized. If the CRA manifested the parties' understanding that the ALA was a done deal, there would have been no need for roughly 6 more months of negotiations, nor any reason for Lively to decline to sign. 3, even if the ALA was a valid agreement, the execution condition precedent bars Lively from enforcing it. Lively also ignores that even if the ALA were a valid agreement or defendants are stopped from arguing otherwise, the execution condition precedent would still prevent her from enforcing the ALA, as well as the CRA, which was incorporated into the ALA. The draft ALA made execution a non-mutual condition precedent to Ends With Us movies obligations, not a condition precedent to contract formation. Conceding execution was a condition to companies' obligation under this agreement. Williston on okay, that's all case law. Thus, even if a valid agreement were formed, Lively cannot enforce that agreement because the Ends With Us movies obligations were never triggered. C, the CRA is not binding or enforceable against the entity defendants. 1, Lively's defense of the CRA's enforceability rests almost entirely on her contention that the ALA was binding and enforceable, and therefore fails for the same reasons. Lively suggests the parties would not have bothered to execute the CRA at all unless they intended it to function as an independent agreement, but no such intent is expressly set forth in any writing. Instead, the CRA says the opposite. Indeed, there's an obvious reason why the parties intended to have the CRA incorporated into the ALA. The draft ALA contained an entire agreement provision that refused recognition of any other agreements. If the CRA had not contained words incorporating it into the draft ALA and had not been separately signed, it would have been a nullity had the ALA never been finalized. 2, Lively's observation that contract modifications do not require new consideration is besides the point because defendant's consideration agreement only goes to whether the CRA is enforceable as an independent agreement. Lively says the CRA was supported by consideration because her obligation to continue filming was doubtful insofar as she possessed a right under the ALA in a provision never subject to dispute to terminate the agreement in the event the sexual harassment took place. That claim is another blatant distortion, however. The sexual harassment provision was edited to permit Lively to terminate only after the CRA was signed. At the time the CRA was signed, Lively had no such right to terminate. Her obligation to perform was required under the offer letter, as she concedes. Lively's claims that there was consideration because she agreed to forbear a claim is also wrong. As she admits, the CRA contained no such promise, and Lively's attorneys had in fact reserved all legal rights to bring claim. D, Lively's contract claim fail even if the ALA and or CRA are enforceable. 1, Lively did not provide requisite notice. Lively does not dispute that she did not satisfy the notice and cure provision in the ALA before suing. She claims defendants waived the notice and cure by failing to include it in its affirmative defense. But courts applying California law have held compliance with contractual notice and cure provisions must be pleaded by the plaintiff and need not be asserted as an affirmative defense. The sole case Lively cites for the proposition that failure to comply with a notice provision is an affirmative defense applied in New York law. That decision also turned on the specific language of the provision at issue, which made notice a condition precedent to suit, unlike the notice provision in the ALA, which states that no act or omission of events with this movie shall constitute an event of default or breach, absent notice and an opportunity to cure. Lively's contention that she satisfied the provision by amending outside or cure period after her initial complaint provided written notice is absurd. A party cannot evade clear notice and cure requirements by simply filing a lawsuit and then amending once the cure period has run. The purpose of giving notice of breach would be completely undermined if it could be satisfied with the giving a post-suit notice. 2. Lively's damages are barred. Lively does not dispute that she can't seek duplicative recovery for the same injury by asserting overlapping tort and contract claims. Since her claimed contract damages entirely mirror her alleged tort damages, her contract claims fail. Lively also offers no real response to defendants, showing that if the ALA is binding, its limitations on damages provision bars most of, if not all, her contract damages, and that all her other alleged damages, such as her redacted, are unavailable for breach of contract. Lively does not even attempt to defend and therefore abandons all her contractual damages claims other than those for the breach of the CRA's anti-retaliation provision. As to the alleged breach of the CRA, Lively argues in conclusionary fashion that her alleged injury constitutes general damages, but the case she cites for that proposition hurts rather than helps her. There, the California Supreme Court held that profits the plaintiff might have earned from unrelated future contracts are not general damages and were too remote to be available as specific damages, even though, unlike here, there was no specific contractual special damages waiver and the industry at issue, construction, was far from more predictable than the film industry. Luis Jorge dooms Lively's damages claims. 6. The defamation and false light claims fail. Lively cannot salvage her defamation claim. Lively concedes, as she must, that her defamation claim is based entirely on defense counsel's denials of Lively's allegations asserted after litigation commenced in the context of discussion of litigation. That concession is fatal to her claim. 1. Lively cannot establish falsity or malice. A. Contrary to Lively's assertions, defendants have made a strong showing that no actionable harassment or retaliation occurred as discussed. Accordingly, statements denying Lively's claims are true, or at least substantially true, which is all that is required to defeat a defamation claim. Lively does not meaningfully dispute that what constitutes retaliation, harassment, or a smear campaign is imprecise and subjective, such that a denial of such context constitutes an actionable opinion. Lively attempts to distinguish Coleman versus Grand on the ground that here the alleged defamatory statements imply undisclosed facts and as such are mixed rather than pure opinions. But one can scour the alleged defamatory statements for any suggestion of undisclosed facts. The statements, viewed in their entirety rather than via Lively's cherry-picked experts, repeatedly disclose the basis for the opinions expressed. B. Lively also fails to muster evidence sufficient to prove actual malice with convincing clarity, as she concedes is her burden. Lively reiterates her argument that defendants must have acted with malice because they knew that Lively complained of supposed harassment on set. Lively does not respond, however, to the obvious point that knowledge of a complaint is not knowledge of that harassment had, in fact, occurred. Lively distorts the record by claiming Baldoni, Heath, and Sarowitz admitted Lively genuinely believes her claims. But the cited text message shows Baldoni agreed with Nathan's comments. We also know there was no truth to anything, while merely noting that nonetheless, Lively is the kind of person that genuinely believes she has the right and that all of this is unjust. That evidence hurts rather than helps Lively's claim. C. Lively argues for the first time that the statements were false and published with malice because they assert Lively lied about harassment to gain control of the film's marketing. This novel theory appears nowhere in Lively's Second Amendment complaint. In any event, none of them specifically say Lively fabricated claims to take over the film's marketing. 2. Lively fails to rebut
that the allegedly defamatory statements are absolutely privileged. A. Lively first suggests the fair report privilege does not apply because an ordinary reader or viewer would not perceive defense counsel's statements as reporting on the proceedings. But a fair reading in the context of the publication as a whole shows these statements were clearly comments on the litigation and mirrored defendant's position throughout litigation. For example, the article that includes the January 18th statement makes clear the statements were discussing and describing Baldoni's long-expected lawsuit filed days earlier. Similarly, the January 7th statement is part of a video embedded in an article about the ongoing litigation, and the specific statement was contrary to defendant's complaint against New York Times. Plus, discussion of documents that only 10 days later would be attached to defendant's complaint against Lively. Lively's arguments that the December 21st statement to New York Times did not give readers any way to understand that it referenced Lively's CRD complaint, as opposed to the New York Times article itself, is even more absurd because the subject matter of the New York Times article and the CRD complaint were essentially the same. In any event, it is not necessary that the court filing, the court, or the jurisdiction be specifically identified in the article for the fair report privilege to apply. And a statement need not reproduce a court filing or proceed verbatim for the privilege to apply. Comments that essentially summarize or restate the allegations of a pleading filed in an action are the type of statements that fall within the privilege. Moreover, it is besides the point that certain statements were made shortly before defendants filed their claims against Lively, because privilege can apply even before a complaint is formally filed, so long as the litigation is anticipated. And Lively's contention that the privilege should not apply because defendants' claims were frivolous fails for reasons described in defendant's opposition to Lively's Rule 11 sanctions motion. B. Lively has no answer for the First Amendment concerns raised by recognizing a defamation claim based on a lawyer's vigorous denial of allegations against his client. Her only response is that the allegedly defamatory statements were not general denials and instead suggested Lively would be proven a liar. But it is difficult to imagine any denial that would not at least implicitly convey Lively's claims were false, i.e., that she had lied. Lively also has specifically alleged that the statements that her accusations were categorically false was defamatory. It is difficult to imagine a clear general denial. First bullet, permitting Lively's defamation claim to proceed risks chilling attorney's ability to deny accusations against her clients. Sorry, you guys, that was a rough read there. B, Lively's false light claims fail. 1. New York law applies foreclosing the claim. Lively's choice of law argument assumes the California choice of law provision in the unexecuted ALA applies, but for the reasons explained supra, the ALA is not binding or enforceable. Lively's arguments fail in any case because the ALA does not bind the defendants who were never parties to the ALA draft. The general rule is that a contract cannot bind a non-party. Lively attempts to end run this rule by calling these defendants closely related parties of It Ends With Us movie, but her own case undermines the argument. Loan Care LLC versus DeMont and Associates LLC concerned a party that purchased the contracting party's assets and continued in its operation after expressly agreeing to perform under the contract, essentially inheriting the contract and its choice of law provision. The facts of this case are not comparable. VTX Com LLC versus AT&T Inc. observed that a non-signatory can embrace a contract's choice of law provision by knowingly seeking and obtaining direct benefits from that contract, and held non-signatories bound in part based on allegations of self-dealing conduct through which the contracts directly benefited the non-signatories. Here, there is no allegation of self-dealing. The only benefits the non-signatories received from the contract were entirely indirect. And in Lipcon versus Underwriters at Lloyd's London, the non-signatories at issue were spouses to the relevant agreements and sued
to enforce rights arising out of the agreement such that the court concluded their interests were completely derivative. These cases do not support the conclusion that Wayfarer, Baldoni, Heath, and Sarowitz must defend a false light claim under California law, and the argument is even weaker still as to Nathan, Tagg, and Abel. Lively has not even demonstrated, for example, that any defendant was aware of the clause. Lively separately argues for application of California law, pointing to what she describes as California conduct. This argument is blind to choice of law principles that favor application of New York law. The overwhelming balance of conduct indisputably occurred in New York or New Jersey, including Lively's pre-filming conversations with Baldoni, Lively's mid-production conversations with defendants about their conduct, defendants' alleged on-set behavior, and the premiere of the film attended by Lively and Baldoni. She claims defendants executed a communication strategy from California, but overlooks detailed allegations in her own pleading that placed defendants and herself in California when the alleged strategy was purportedly hatched. She further ignores that the defamatory statements and media of which she complains emanated primarily from New York, where she resided at all relevant times. In short, the most significant relationship factors clearly support application of New York law. 2, Lively has no standing under California law. Lively would fare no better even if California law applied. Indisputably a New York resident, she asked the court to ignore the impressive body of authority that limits standing to California residents. Relying on no contrary authority, she cites only Doe versus Meta Platforms. That case does not confer standing upon a New York plaintiff to bring a false light claim. Far from it, the court noted it was not determining or foreclosing the standing argument and ultimately dismissed the constitutional invasion of privacy claims as then pled. Lively argues her claim does not depend on the California Constitution and can proceed under the common law, citing Hill versus National Collegiate Athletic Association. Lively's Second Amendment complaint, however, pleads a claim only under California Constitution art and not under common law. Second Amendment complaint at paragraph 139. Okay. Moreover, a common law claim would not be actionable based on the mere discrimination of truth newsworthy material. And as noted above, Lively fails to identify any discrimination. And as noted above, Lively fails to identify any dissemination of false information. 6, Lively's conspiracy claim fails. Lively concedes conspiracy liability cannot arise from contract claims, and she fails to meaningfully oppose defendants' arguments that New York conspiracy liability cannot attach to California's FEHA and federal Title VII claims. Her conspiracy claims are entirely duplicative of her underlying tort claims and must be dismissed for that reason alone, let alone that none of her allegation torts can survive summary judgment. 8, defendants Sarowitz must be dismissed. Lively strains to implicate Sarowitz despite his undisputably peripheral role. She claims, but without evidence, that he was on set during the birthing scene. Lively's declaration states only that Sarowitz was present on the set that day without specifying any scene or shoot he attended. Multiple scenes were shot the same day. While not disputing that Sarowitz had no contact with the PR firms allegedly responsible for the alleged smear campaign, at least not before this litigation began, Lively claims Sarowitz is nonetheless liable because he made a suggestion about flipping the narrative. She admits, however, that suggestion merely brought to light the truthful fact that her husband, a male, rewrote portions of the original female script. Lively also fails to identify any evidence to support her claim that Sarowitz threatened to ruin her family. Undisputed evidence shows Sarowitz never made such a threat. 9, Lively fails to oppose defendants' damages arguments. Lively's damages arguments confuse the issue. She claims standing to pursue damages to her own reputation, but falsely equates personal reputational harm with the speculative lost profits purportedly sustained by separate businesses. She has no standing to seek such damages which are in any case too speculative. Cantu versus Flanagan only underscores the point. Cantu was personally awarded non-economic damages, not for speculative lost profits, but because the harm to his reputation directly resulted in his inability to secure oil and gas with an identified value. Lively's other cited cases are in opposite and concern entirely distinct issues, such as standing to sue on a contract. See NAF Holdings LLC versus Lee and Fung Trading Limited, or standing to sue corporations based on the corporate misrepresentations to the plaintiffs, such as Citigroup Inc. versus AHW in whatever. I don't even know what that says. Lively cannot dispute that the business entities she redacted. Conclusion: for the foregoing reasons and those stated in the prior briefing, the court should grant summary judgment in the Wayfarer party's favor on Lively's claims, signed by none other than Alexandra Shapiro. And this was dated December 12th, 2025. That concludes this reading. You guys, that was a little rough for me. I'm sorry. It was very long, a lot of technical terms, a lot of cases cited. If you enjoyed this reading, please let me know so I know whether or not I should continue doing these. And I really appreciate all of your time and being here and checking out my channel. Please like and subscribe. See you guys soon.